Welcome in on this Sunday night of a holiday weekend. It is the end of May, and that means it's busy season at the Supreme Court as the justices hustle to finish all of their outstanding opinions before they rise for their summer recess. That usually happens around the end of June, and we're still waiting on major decisions on student loans, affirmative action, race and gerrymandering, LGBTQ free speech, and voting rights. Now, the justices, they've got 30 more cases to resolve before the end of the term. We got 3 opinions this week. Let's dive into them. First up, the Supreme Court significantly limited clean water protections that can be imposed by the federal government. There's an Idaho couple who wants to build on their land. They got blocked by the Environmental Protection Agency under the Clean Water Act. That's the main law that regulates water pollution throughout the country. And a majority of the court's conservative justices limited what counts as a, quote, wetland. So think marshes or bogs or something like the Everglades in Florida. Now, limiting what is a wetland means limiting how far the EPA can go in protecting them. Next up, one that we can all get on board with, a 94-year-old woman who had racked up $15,000 in debt after not paying her property taxes for several years. A Minnesota county took her home. They sold it for $40,000 and they pocketed the extra $25,000 they made on the side instead of giving it back to her. Now, she filed a lawsuit saying that violates the Takings Clause of the Fifth Amendment. The Takings Clause says the government can't take your property without just compensation. And lower courts went against her, but the Supreme Court unanimously sided with her, holding that she made a pretty good case that the government screwed this one up. And finally, right here in our backyard, the court unanimously sided with Maryland prison officials who are facing a civil rights lawsuit for beating a man being held before trial. After Kevin Younger was left bloodied and unconscious in his Baltimore prison cell, he sued and a jury awarded him $700,000. The case is a technical one about when you're required to raise certain arguments during the course of a case. But the bottom line here is the prison officials get to keep fighting the jury verdict that was awarded to Younger. Now, that's 3 down, 30 opinions to go by the end of June, and that's really just the court's merits docket, where they formally accept requests, they hear cases, they get full briefing, they have an oral argument, and then they release a written opinion explaining how they come down. There is another big chunk of the court's work that isn't the merits docket. It's called the Shadow Docket, and it deals with emergency orders and other things, everything that's not the court's merits docket. So WTF is the Shadow Docket exactly? Well, we've talked about it a lot on this show, but it's when the court, for the most part, receives emergency requests from people who say they need immediate action on something. These are often procedural questions, but they can have monumental implications. We saw it recently in the mifepristone case, where the court's Shadow Docket decision preserved access to the most common method of medication abortion, at least for now. Unlike the merits docket, we don't often know how each justice votes for those decisions, nor do we get much of an explanation of their reasoning. The term Shadow Docket was coined by Chicago law professor William Bode, and joining us now to talk about this important piece of the court's work, University of Texas law professor, and now New York Times bestselling author of his brand new book, The Shadow Docket, Professor Steve Vladeck. Professor, thanks for joining us.
Thanks for having me, Katie.
So we have been talking a lot more about the Shadow Docket in the press. You wrote a book about it, but the Shadow Docket, or the emergency orders docket, has been around for a long time. But getting at one of the questions that I think underscores your book, what's new here? What has happened that's making us talk about it more?
Yeah, so obviously the Supreme Court has always had a mechanism for handing down unsigned, unexplained orders that were principally about managing the docket, whether it's an emergency application, whether it's an order granting or denying discretionary review, a writ of certiorari. What I think has changed so profoundly in the last 6 or 7 years, what the book really tries to document, is that as recently as 10, 20, 30 years ago, most of the emergency action that we saw from the Supreme Court involved last-minute appeals in death penalty cases. And those obviously have a lot of enormous stakes for the party, for the victims, for the state trying to execute a prisoner, but they didn't tend to affect statewide and nationwide policy. The shift we've seen in the last 6 or 7 years is how routine it has become for the justices to be asked to intervene and often to agree to intervene where we have a nationwide or a statewide policy at issue. You mentioned mifepristone. There's also the court's non-intervention to block the 6-week abortion ban in Texas. There's the blocking of the Biden administration's testing or vaccination mandate for employees of large businesses. And so, Katie, across the entire gamut of high-profile lawsuits, of high-profile social issues, we're seeing emergency applications playing a much greater and more frequent role in shaping the law on the ground for months, if not years on end.
And there are different buckets of shadow docket decisions that you look at throughout the book. And in some, there are explanations for perhaps why and how the court is going the way that it is. But when you look at all of the decisions as a whole, particularly going back to 2017, diving in on some of the COVID decisions and how that changed when there was a new administration in town, there really is one explanation now for how the court is responding. What is that?
Well, I mean, I think that the best predictor, at least for a large chunk of the last 5 or 6 years, has been the partisan valence of the dispute. So, one of the problems once we start looking more closely at the entire field of unsigned, unexplained orders is that they tend to defy coherent neutral through lines. So we saw, for example, over and over again during the Trump administration, that the Supreme Court would step in and grant emergency relief after lower courts had issued nationwide injunctions blocking Trump immigration policies. We saw a host of unsigned, unexplained orders from the court saying, no, go ahead. You should be able to carry out your immigration policies. Katie, where the arguments for doing so were grounded in some combination of deference to the executive in the sphere of immigration and hostility to nationwide injunctions. Fast forward to 2021, 2022, and now this year, and we're not seeing the same when the Biden administration goes to the court and says, we would like the same deference, we would like you to be just as hostile to nationwide injunctions. Now the court is denying applications for emergency relief in immigration cases. Katie, that's the problem the book tries to document, which is when the justices are not providing rationales, when we are left to speculate as to why case A comes out one way and case B comes out another way when they look so similar, it really doesn't do any favors to the court that the best explanation is simply the partisan valence of the dispute. There's no response from the justices when they're not providing a rationale and an explanation.
Providing us a rationale is a good way of putting it. Judges, lower court judges, and justices have said publicly, look, we are the one branch of government where we have to show our work. We have to provide you an explanation, a written opinion, something that you learn to do beginning in kindergarten and math class in elementary school. Show how you got there and why. You might not agree with the principle, but you agree that there are principles. Now, in the shadow docket, we don't always get the show your work principle. So 2 questions here. What is that? What effect is that having? And 2, showing your work means that there is then precedent, which we don't necessarily have with all shadow docket decisions. But are shadow docket decisions considered precedent that the court is then bound by or has to rely on?
I mean, yeah, so this is one of the shifts that we've seen in the last couple of years. In that, you had mentioned the COVID cases. There's a series of emergency orders from the Supreme Court in early 2021, mostly restricting COVID mitigation policies in blue states like California and New York, where, Katie, we see for the first time the justices treating these unsigned, unexplained orders as precedents. We see, for example, the court sending other cases back to the lower courts for further consideration in light of an unsigned, unexplained order.
Right.
We have one, I think, really, really visible example where the court actually writes a couple of sentences about how the Court of Appeals, the Ninth Circuit on the West Coast, had clearly erred by failing to follow an unsigned, unexplained order in an earlier case. And this, to me, is really what drives home the problem here. If the justices are at the same time not providing a rationale, but expecting lower courts to follow the tea leaves that is sort of, buried within the unsigned, unexplained order, that's where this really starts to depart from pretty well settled traditional principles of judicial decision making.
And that's
where the
where
appearance
we would encourage people to also dig into the book here because it really explains the issue there for the court. Steve Vladeck, thank you so much for taking the time to join us. The book is called The Shadow Docket. You can get it online at your local bookstore, or you can listen to it on Audible as you are hopping around town. Thank you, Professor. All right, coming up next, we are talking to parents filing a lawsuit against a local school admissions policy. They faced a setback in court, but they vowed to keep fighting. I'll speak with one parent who's a part of the group that's filed the lawsuit, coming up next.